All right. All right. I'm here. I'm here. And my headphone cord decided now was the time to get twisted. I untwisted it before I got started, but apparently not good enough. Hopefully now it won't drive me nuts. And I haven't shared my screen yet. So how about we get this shit show on the road? And by shit show, I mean the trial, not me, because I'd never present a shit show. So yeah, it's over ish. We've got the closing arguments today, and it'll be little Alan Jackson and Lolly will do the closings. And so the chatter yesterday that McLaughlin would do the closing for the state, I might have misunderstood the comment that said it. So either way, it is Lolly. Should be fun. And by fun, I mean a shit show, at least from little Alan Jackson. But yeah, so Bad Scooter. Have fun finishing up at work. It's if you're on the East Coast, hour to go, maybe. You work 9 to 5. I mean, I figure if Dolly Parton sings about it, 9 to 5 is probably good enough for me. And Vince, hey, we're counting now. Lisa, good to see you. And James, Frank, good to see you. And Luna and BB. And well, and that's basically Frank. Yesterday I said, when I debated, do I do it live? Or do I wait and just do my sort of standardish time? And I figured, well, some people do watch someone else in the morning and then come to me. So yeah, I'm doing it now just for you, Frank. So yeah, like I said, we will watch the closing arguments. In real time, the jury already has the case. Painted Bronco and Pat's Cats, good to see you. And frankly, I don't know Sunken Grave. That's something we're going to discuss a little bit. Of course, some of the jurors were going to get dismissed anyway, or at least get sent to a different room, because only the 12 jurors get to deliberate. Any alternates don't. But they still might not be released, just in case, it's a multi-day deliberation or there's misconduct or something. And so sometimes what courts will do is, they'll take the alternates and they'll be like, yep, so as long as the actual jury is deliberating, you alternates are here because you're still sequestered as alternate jurors, just in case you need to step up to the bat and they're, sent off to watch a movie or something in the other conference room. And yeah, but from what little I've heard, that might not be the case. Like, they might have been dismissed for cause or, for bad behavior, for something. I don't know. But Casey, good to see you. I hope that, well, I was going to say Blighty, but I don't know that you're specifically in London. So I hope England is treating you well today. And Grey Duck, I would never curse at little Alan Jackson. I will have invectives aimed at him, but I would never curse at him. Come on, come on. And so, yep, Sonny, I have seen nothing. I've seen nothing. I see nothing. But yeah, that as usual, this is my blind reaction. So yeah. And BB, yeah, yeah. He's a toddler telling a story and getting real upset and putting on his "I'm mad" face when mom tells him, "That's nice, dear." That I think you've got it. So, and that's it, Frank. I think McLaughlin is the writer. She's the researcher. There's a reason we hear her argue motions. She's the writer. She's the analytical one. Not saying that Lolly isn't, but that seems to be her specialty. And Wicket, good to see you. And Dolly, like, I'll admit, Dolly's music isn't for me, but as a person, Dolly is lovely. She's lovely. So yeah. Um and I'm so happy, Pat's Cats, that this is the end. Um yeah. Why would I ever rant about little Alan Jackson? Come on, corrections. Um, but good to see you. And Kevin, I have no influence over anyone. Come on, what are you talking about? And so one dismissal. I like I said, I saw chatter that maybe it was one, maybe it was two, but two alternates. We started the trial with 6 alternates, didn't we? Or were there just 4? So, Dante, I hope you voted. And anyone lurking that's from Utah, remember today is primary election day. So if you haven't voted yet, do it. If my cousin is watching, make sure you've voted. Portsmouth. Okay. My parents are going on a cruise around the British Isles later this year. I think they're leaving out of Portsmouth. But it might be Southampton. But I think it's Portsmouth. So I'll have them wave to you from the ship. And that could be it. That he was just the spoiled child that never grew up, both literally and figuratively. So Vince, I would expect that from Brandon. So did you miss any dad jokes today, Brandon? Just that one. Just the writer. I don't even know her. So Debbie, in the future, I hope you've enjoyed the next 16 days of trial that you're catching up on. Oof. I'm gonna do my best to forget it. So yeah, twerp is a good description. And that's it. That, like, it really is a kick in the teeth for the alternate jurors. Like, I spent 8 weeks, missed all that work, and and I don't even get to deliberate. My opinion is doesn't matter. It's the legal equivalent of blue balling someone. It's just not right. Although in this case, it is a necessary evil. So, all right. I hope that work is ending soon for you, Bad Scooter, and that it has been a good day. So, let's see. Oh, well, that's interesting. That's interesting. It would be interesting if Turtle Boy got jury tampering charges for that. Like, if the juror got dismissed because they were on Turtle Boy's side, were were they a plant? Did they lie in the voir dire? Did Turtle Boy contact them? Has he been contacting them? Like, that that would be real interesting if Turtle Boy gets jury tampering charges on top of his witness tampering charges. That would be hilarious. That would be hilarious. So I think Trey and Matt from South Park would be able to do it justice. Because obviously it would have to be satire. It would have to be satire. So, well, I guess if Turtle Boy's going to be hugely anything, it would have to be mad because, you know, he's just like little Alan Jackson. He's got the little man syndrome, and as I've said, I'm not overly tall myself, but little man syndrome isn't about height. It's about attitude. And you can have little man syndrome at 6'6" if you're angry that you're not 7 feet tall. So yeah. And Kfar, good to see you. It absolutely, well, I mean, it's been wild for a while. It's been wild for a while. So luckily the wildness is coming to an end. So I'm hoping that I was correct and that I'm hoping for a verdict on Friday. And part of that is I'm hoping it's not tomorrow, just because if it does come tomorrow, I might have to cover it later than I would prefer. Like, it, if we get a verdict tomorrow, it might be an evening stream instead of a mid-afternoon stream, my time. Just other stuff might be in the way. So just a warning that might be the case. So before we get started, like properly, I was thinking last night, and that's always a dangerous thing with me, as you know. And it's just, as you've noticed, I really got upset with the judge that she treated Lolly differently, more harshly than little Alan Jackson. If a witness was answering and Lolly would interrupt, the judge would immediately get upset. But with little Alan Jackson, he could shout them down, yes or no, yes or no, that's no, like, and I I wonder if part of that, like, it's inappropriate either way, but part of me is wondering, well, is it just that she has a working relationship with Lolly since, she's a judge in the same county, he's a prosecutor. He he um, he does go in front of other judges in the county, but like she sees him all the time on other cases. They've worked together for presumably years. Whereas this is her first experience with little Alan Jackson. No rapport, no working knowledge of each other. And so the phrase familiarity breeds contempt. And like I'm with my family, I'm their fiercest advocates, but I'm also their harshest critics. No one tears into you like family does. And I almost wonder, is that, I mean, it could also be just, familiarity has bred contempt in that she doesn't like working with Lolly. But I almost wonder if it's just she's never worked with Jackson before, so she gave him more leeway. It's still wrong. It's still wrong, but I almost wonder if that's what it was. So, and Brandon, you are my number one priority in life. Everyone else, though, comes after my family. So, sadly, though, I can't do a private stream just for you tomorrow. And the jury has a question. That happens. Yeah. You're terrible. You're terrible, Vince. So yeah, and it looks like I've got the stream set to sort of the very first instance of in court camera. It looks like it's only up for a minute. I don't know what's going on. I'm assuming that's because of the juror intrigue. So we will end up fast forwarding like almost immediately after starting, but then we'll get into it. We I still have, I have this stream on my normal settings. Oopsie, news just dismissed. Like, is that a member of the media was kicked out of the courtroom, or another juror dismissed. So, but yeah, we'll be at 1 1/4 speed. I don't have it on subscribers only mode. I have a feeling we might get more morons in this stream than usual, just due to it being closing arguments. So I might change it to subscribers only if it, if it looks like it might be necessary. That way, they can subscribe if they want to be trolls in my comment section. But all right, jury going home for the day. Got it. And the thing is, I just, like, even as a defense attorney, I don't agree with being in favor of the defense, going easy on the defense, however you want to put it, because everyone needs due process, including the state, including the victims, and it just rubs me the wrong way. The rules are the rules, and so both sides should follow them equally, and both sides should be held to them equally. But that's my opinion. So and the thing is, Vince, part of it is, like, that's how some of the channels grow, like forced subscriber growth. And I see pros and cons to it. Sometimes I feel I should do that, but then at other times I'm like, but it's also kind of dickish. So either way, let's hit play for a minute and see what happens for a minute, and then go forward. So, I've got you, Vince. And Judge A was definitely
You are
good.
unmuted.
All right. I need to see counsel with sidebar.
Well, yep, that really was a whole lot of nothing. Just immediate. And that was just for you, Brandon, I think. The immediate, I need to see counsel at sidebar. Like I said, I don't know if that was the jurors dealing with the jurors, or yeah. So, well, and I know, BB, I saw there was a little bit. I didn't know if something would be said. So the rule of completeness and all that. That could also be what it is. The ironing out the instructions.
Back to session, you may be seated.
And Jen McCabe is sitting behind the O'Keefes. And Brian Albert is next to her. And that's not necessarily that they were arrested or detained. It's let out by a court officer. Could just be they were escorted out. But Grey Duck does ask a good question. Does that juror drive a new Lexus? Do they have a car seat in Turtle Boy's Lexus? Okay, so apparently this is a whole bunch of nothing as well. Is that Colin behind John? So yeah, we've got Colin Albert behind John, Jen McCabe behind Aaron. We've got Brian Albert next to her. But we'll go to here.
All persons having any business before the Honorable Beverly Kenobi, Justice of the Norfolk Superior Court, uniformly County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of this.
Personal to that juror, like their personal relationship with Turtle Boy?
Please disregard that. Okay? I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I'm just talking.
Not necessarily. Not necessarily. I mean, the juror can say it might end up in a transcript somewhere, but might be sealed. Like, no idea.
You think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And we've all seen how hard the lawyers have worked for this long period of time. We've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Thank you, Your Honor.
And remember, it's weird. Massachusetts is weird in that the defense gives their closing first, because everywhere the prosecution has the opportunity to have the last word because they have the burden of proof. So if you have the burden of proof, you get the last word. And usually that means the prosecutor gives its closing, reserves 10 minutes of it. The defense gives their closing, and then the prosecution gives that last 10 minutes, and we're done. Here, the defense goes, the prosecution goes, then we're done. So it's weird, but we get little Alan Jackson first, and he'll probably have his I'm real angry face on throughout. And I have a feeling this hasn't impacted Lexus in the slightest, other than, the sale of a couple extra taillights for the dipshit with the potato gun. And I was going to mention earlier, but got off on other tangents. So those experts yesterday that the state or that the defense brought were terrible, I thought. And it as I said, it's an example of garbage in, garbage out. And Lolly, right there at the very end, he was like one question away from just one question away. Because the dipshit did his analysis. It was a binary analysis. It was either he was hit head on, full force, and that couldn't have happened. That would have caused a lot more injuries. Or, Lolly asked, what about a side swipe? And, well, that wouldn't have thrown him because not enough energy at 24 miles an hour. And it's like, what if he was hit mostly side swipe with a little backward energy, like right there on the corner, like one question away. And it really annoys me that he didn't quite go far enough on that cross. But as I've said multiple times, I think I even said it at the beginning of yesterday, because, in response to the person that left the comment saying, the state's witness said it could be, it might not be, but it could be this, whereas the dog bite lady said it is a dog bite, and therefore reasonable doubt, she said unequivocally it's a dog bite, therefore it's a dog bite. But as I've said, the jury, number one, gets to decide which evidence to give weight to. If they didn't believe the dog bite lady, they don't have to say it was a dog bite. But the jury, as I've said multiple times, can make reasonable inferences based on the evidence. And so I kept saying yesterday, to me, the brunt of the impact was John's upper arm. The elbow is probably what broke the taillight. And the reason I say this is it's the right height. It's the right height. It primarily brushed, the taillight primarily brushed past, creating the scratches. Continues, hits the hand, that provides some rotation as he is sent flying. It's not a full force impact. And this, to me, the jury can make this reasonable inference. It would have been made easier to make that reasonable inference had Lolly asked that one extra question. But they can make the reasonable inference. We don't have to know exactly the mechanism she hit him with, because the evidence is there that she hit him. We don't have to know the exact spot of impact. It would be helpful. It would be nice to know. But frankly, we need to know, did she hit him or didn't she? And to me, the evidence says she hit him. And I wish Lolly had gone that one extra step, just, couple extra questions would have got there. And yeah, that they were hired by the feds, these experts, and as we heard, they didn't get the evidence. Garbage in, garbage out. They didn't get the evidence, so how can we trust their analysis if they're not even given the evidence? And that's it. It's a relatively high taillight. And by Kevin, I assume you mean Yellow Cottage Tails, Kevin. And that's, you know, that it's an example of the CSI effect. We've mentioned it before, where, you know, we expect DNA results in every case, even if you don't need DNA results. We want video evidence in every case. You know, if you go to the zone of death in Yellowstone and you're murdered, there's not going to be any video evidence. You're in the wilderness. Does that mean your murder doesn't count? I mean, for jurisdictional issues, maybe, but like people, because of the CSI effect, are willing to discount other forms of evidence. How many times have we heard after eyewitness testimony, well, there's no evidence, but the eyewitness testimony is evidence? And it's just, and that's just laziness on the part of those police officers. You know, I mean, if there's not good evidence outside of video evidence, you know, maybe, but lack of video evidence, it shouldn't necessarily mean innocence. And we're reaching the point where, you know, can you trust video evidence? You know, with all the deep fakes and all that, can you even trust video evidence anymore, or to the right extent? So it was expensive and too much speculation, too many variables, because once again, this is how it could have happened. So, but that said, let's hear from little Alan Jackson. Ugh.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case.
Fuck off.
4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way.
Fuck off.
Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials.
Falsified affidavits? What the hell are you talking about? Falsified affidavits? Ugh.
Galore. Just look the other way. That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom.
By you. By you.
And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a
Woe betide anyone? Seriously?
Proctor. Preparing for today, I was reminded of a quote. It's a quote.
And once again, he says conflicts of interest. He says conflicts of interest. Trooper Proctor had no conflict of interest. He really didn't. He didn't know Brian Albert. He didn't know the actual witnesses. By the time the defense concocted the conspiracy about Colin and Chris Albert, who, once again, were not there. By the time the defense concocted that theory, Trooper Proctor had already investigated the case. It wasn't a conflict of interest. The Canton Police Department, it wasn't a conflict of interest providing their Sally port. Sergeant Lank and Good wasn't a conflict of interest to be on the scene before the state troopers took jurisdiction. They just, ugh.
What about the truth? And I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time. And a third.
Like you.
This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer.
So you're
One
a
lie begets
cancer.
another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper.
How is a unhinged conspiracy born? Out of your cancerous untruths?
Says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl.
No. He said serious charges were coming because he had already found evidence to charge her with serious crimes.
You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information.
But you did.
They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to
Little
wonder
Alan
if
Jackson.
they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink. They don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple.
By you. The conspiracy is you. You. The cover-up is your shoe lifts. Giovanna, good to see you. And he's talking about himself. He's talking about Turtle Boy. He's talking about David Yannetti. Daddy Reed. Ooh.
You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen?
you.
How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep them close. Offer them help. Offer them.
Handpick your investigator? Handpick your investigator? What the fuck are you talking about? Trooper Proctor wasn't handpicked. He was on call. He was on call. Look, handpicked? You mean when they set the schedule in the past? That was handpicking the investigator? How? How? I mean, like, if the on-call schedule had been out for 2 months, did they handpick him a month before the Aruba incident? Seriously? And handpicked the investigator who never was alone, never conducted interviews alone, always had Sergeant Buchanan or Lieutenant Tully, or you know, they worked in pairs. How? And once I finished my rant, I was going to mention that he does look like he's trying to squeeze one out in this very unfortunate pause. Be a shame if someone were to clip this and put it on a billboard for him.
Gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches.
They got their story straight. No, they didn't. The entire Free Karen Reed conspiracy was, this witness was 5 minutes off from this witness, and da 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 da, even though it was 2 years ago and they were drunk. If they got their story straight, you'd think they'd all be telling the exact same story. The little inconsistencies within the same story arc is what tells you they're testifying from their memory, not from the agreed upon official story.
Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones.
Fuck off.
Destroy your SIM card. For the investigator.
Which they were allowed to do. I mean, did Karen willingly hand over her phone? And once again, repeat after me, fuck you, get a warrant.
Decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative.
Question all the witnesses together? What are you talking about? Fuck you, get a warrant wasn't number 5, Kevin. That wasn't number 5. That wasn't aimed at Alan Jackson. That was aimed at you guys. But the Kevin. You're supposed to be counting how many times I swear at little Alan Jackson. Those 5 and 6 don't count. They weren't aimed at him. But you made me lose my train of thought. He says witnesses were interviewed together. No, they were not. They weren't. They were in the same house. They were in the same house. But the testimony is they were interviewed one at a time. The others were sent out of the room. Like I've said, I need to get out of that habit. Little Alan Jackson is a lying toad.
Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence.
All the evidence in the hands of one person? You mean Lieutenant Tully, whose job it is to be the custodian of evidence? He's literally describing standard police procedure as a conspiracy. Standard police procedure as a conspiracy. And once again, the McAlberts were never suspects. There was never any real evidence to make them suspects. So, yeah, they were treated like witnesses. This is how witnesses are treated. At least by the prosecution. The way the defense has treated witnesses in this case has been criminal.
Including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into.
If the timestamp was not inverted, that means that camera was set up inverted in the Stone Age. So the conspiracy goes back to when that potato camera was hung on the wall in the Sally Port.
Into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the.
Delete 42 minutes of security footage. Oh, you mean use a motion activated security camera? Huh? Tell us about the Ring camera video that disappeared. Why don't you tell us about that while you're at it?
The homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you.
No, they didn't.
But
You
this sort of
lied
injustice can't
about
happen in a
them.
vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around?
You mean like, oh, they followed the evidence, the real evidence?
It's a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud.
Like Spaghetti Anetti has?
And make sure you attack her character. And that's what you saw in this case. The Commonwealth spent
no. The Commonwealth has attacked her character? No. No.
Much of their time and resources trying to vilify Karen Reed. They desperately resorted to calling witnesses to talk about Karen Reed and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take
A nice, affectionate evening out with their friends. They talked it out. He needed a ride. He needed a ride. Like, has he never seen a couple put on a mask, put up a front? Like, people you've seen getting divorced. Oh, but they were such a nice couple. That's shocking. It's because they were acting around you. And even if they had made up and had a lovely evening, we've seen it only takes one little slight to turn Karen back into the crazy bitch. Like, oh, I don't know, say Bella's mom.
take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34th Fairview.
He never walked in.
If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into
Only if that argument with a loved one is with a crazy bitch. A crazy drunk bitch at that.
the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in.
Every
the question you have to
witness.
ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something.
All powerful? All powerful? I forgot we're watching the John Gotti trial. I mean, that pause face where I look like he's trying to pinch one off, now he looks satisfied at the smell. Now he looks satisfied at the smell after he pinched it off. Is he even going to address the bad evidence against him? Or against her?
Because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem.
The monotonic time clock, which was it Ian Whiffen or Trooper Guarino that testified about that clock and how it's the app pulling from the battery is so Waze drawing battery power and how that clock isn't necessarily accurate. But we're just going to ignore the other evidence that shows he was half a mile away.
For the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs.
Half a mile away.
And that makes perfect sense, doesn't it?
No.
It matches. Walks into the house.
No.
Goes directly to the basement. There's your 80 steps and your descending flights of stairs.
And he ran 34 miles an hour, 3 flights, down to the basement and back up is 2 flights. So even that's wrong.
Big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly.
All right,
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36.
They've gone for the day, so no decision today.
It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV.
No, they didn't. They didn't testify that Karen was alone. They testified that they only saw Karen. They only saw Karen. That doesn't mean Karen was alone. They didn't see anyone get out. How? So if they didn't see John get out, how is Karen alone in the car? Can't be. Can't be. Besides which, you drive past a car in the dark on the driver's side, you're not paying attention to it, you're not going to see who's in the passenger seat. Frankly, you probably won't even see who's in the driver's seat, but they did testify, though, that, because remember, on Cedar Crest, Karen drove past Fairview, did a U-turn, and so made a right-hand turn onto Fairview right before the truck made a left-hand turn. And the girlfriend testified she saw a passenger. And all of them testified, all 3 testified they didn't see anyone get out. So how did John get in the house if they didn't see anyone get out? How is he in the house, not in the Lexus, as they drive past as they're leaving? He's still in the Lexus. That's how.
John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him.
No, it doesn't.
So it all fits.
No, it doesn't.
And Ryan was right
None of it even put him in the house. All of the data, he didn't get close enough to be in the house.
behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34th Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34th Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They've been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed.
Clearly pining? Excuse me? Clearly pining? I mean, the texts were embarrassing. He, like, asking for clarification from her, like, what are your intentions here? That's clearly pining. Seriously? Like, so clearly pining that like when she didn't respond to one of his texts, he chased after her. Oh wait, no, he didn't. They, like, she left him on red and he didn't contact her again. But that's clearly pining. This is another example of little Alan Jackson being a lizard in a skin suit because he does not understand humans.
Committed to John. You can see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me?
That's pining.
Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear.
That's pining.
So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in.
Fighting.
Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34.
Yeah, that's a great conspiracy you've got there. Like, you're planning to kill someone, so you practice it right in front of him at the bar. That is like the stupidest thing. And that could be it, Vince. It's you coming. It's possible he wanted to show John those texts and say, yeah, so Karen, who's been all lovey-dovey with you all night, these are the texts she's been sending me for the last couple of weeks. You know, you might want to, not. It very well could be he was hoping to get a moment away, a moment alone with John to be bros, basically. Yeah, they're arguing premeditation, and yet the best disposal would be, yeah, the front lawn, that's good enough. No one will suspect us. Yeah, let's practice our techniques right in front of him on camera. This is dumb. D-U-M, dumb. He doesn't even deserve the B at the end of dumb. That's how dumb it is.
Poor Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together?
They didn't say they were out of sight. The other room was like the living room part of the combined kitchen, dining room, living room. Like they weren't out of sight. Where did they go? No one knows. I mean, the Bryans know. Everyone else who could still see them know.
Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long
does it take to have a fight? Maybe the length of the drive from the waterfall to 34 Fairview? Seriously, how long does it take to have a crossword, to have a fight? But yet, John and Karen, they were lovey-dovey at the waterfall. Everyone testified about it. They'd made up from their fight earlier in the day. They couldn't possibly have still been upset at each other. But how long does it take to have a crossword, to start a fight? It can be just like that, the time it takes to walk to the basement. That's enough to form that murderous rage. But that drive past Bella's mom's house, that drive, more than 30 seconds to walk to the basement, that wasn't long enough for Karen to fly into a drunken rage.
What would it take for Brian Higgins to say to John, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in.
And once again, none of this is in evidence. Not a single bit of this is in evidence.
intended to go that far, but what's done
If I were Lolly, frankly, I would have objected. You know, assumes facts not in evidence.
is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it
Is moving cars not administrative?
neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually...
Brian testified she was there. Brian's wife, can't remember her name, testified Chloe was there. And like maybe Jen McCabe rushing into the bedroom at 6 a.m. to say, wake up, John's out dead on the lawn. Maybe she's not looking for Chloe. Maybe she's not looking at Chloe. You know, her attention's elsewhere. I mean, let's conveniently forget about that. And all this nonsense about, oh, they got rid of Chloe because she attacked Johnny. She's a vicious dog. Just look, she attacked another dog. After your psycho bitch client killed John, Chloe attacked another dog. And they sent Chloe to the farm after that. Like, what was that dog attack months later? Was that part of the conspiracy so that they'd have a reason to get rid of Chloe? What, like, seriously? She attacks a dog months later and injures that dog's owner trying to break it up. You know, I can tell you, breaking up a dog fight is not fun. Our old Malamute never would have intentionally bit me. I've got the scar on my elbow trying to break her and my other dog up when they were fighting. But seriously, was that part of the conspiracy? Now, Chloe doesn't like this dog, so you walk it past our house, we'll make sure that Chloe attacks your dog. That way, you know, we've got cover. We've got an excuse to get rid of her. Yeah. That is stupid. That's stupid.
got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not...
Had a bite history 4 months later. The bite history came after. The bite history came after John's death. Like, if you get rid of a dog because of bites, you don't get rid of them because they have a bite future. Because the bite history he's talking about was a bite future at the time of John's death. So if you get rid of a dog because of a bite history, you kind of have to wait until it goes from a bite future to a bite history. Because I don't know if little Alan Jackson realizes this, although this pause face looks like he might be having an epiphany about this. But I don't know if he realizes this because, you know, timey-wimey, wibbly-wobbly, but a bite history would indicate the past. History has already happened. The bite hadn't already happened. So, like, seriously, if you think the bite history was just a cover up to get rid of the dog, to get rid of evidence, are you saying they manufactured the bite in the future? It's stupid. What's not stupid is Esty. Good to see you. And the conspiracy is it's just such nonsense.
Not want law enforcement to find out. Recall what Dr. Russell said. She's seen up to 1,000 animal attacks.
And
In
she
her expert
had
opinion,
no
John's right arm,
credibility.
those injuries are from an animal, quote, most likely a large dog.
And she didn't
Dr. Russell's
examine
testimony, I'll
the
remind you,
body.
is undisputed by any witness for the Commonwealth. But there are more odd and unexplained things.
Undisputed by any witness for the Commonwealth, because we didn't follow the rules, and we sprung it on them at the very last minute. Because, you know, rules for thee, not for me. And it's maddening. Absolutely maddening. And Brittany, good to have you over on Twitch. And yeah, it's, you know, I mentioned all the way back on my preview stream the day before the trial started that my gut instinct was that she hit him. But I didn't know any details. I didn't know if it was second-degree murder, if it was DUI manslaughter, if it was, like, I didn't know. Just my gut instinct was that she hit him. And I realize, as far as YouTube and Twitch lawyers go, I'm kind of in the wilderness in that I really dislike little Alan Jackson. I really think the conspiracy theory is about the stupidest thing I've ever heard. And I've also said I won't give my verdict until after closing for both sides. You might have a feeling what my verdict will be, though.
After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly
Not
that those calls are
incriminating
probably say it
because
with me.
they're not
the butt dials.
suspects.
Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully
But, you know, Karen making phone calls all through the night, that's normal behavior.
defensive about that call. Didn't remember on cross-examination when I was asking her, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls.
Fuck
Nobody knows a
off.
thing. All right, don't talk to anybody until we talk again.
Fuck
Okay,
off.
fine. And by the way, come back over. I need help moving something heavy.
Fuck off.
How long did that take? 15 seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold.
No, she was not. She was Googling Hockomock Sports. You lying prick.
That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else.
It wasn't a focal point of the state's entire case, you muppet. It was the linchpin of your conspiracy, and the state, in order to dot its I's and cross its T's, wanted to disprove your conspiracy so that there was a solid foundation to build their case. If they didn't disprove the 227 search, you would have been the one to bring it up. It's not a linchpin of the case. They are just preemptively disproving your conspiracy. This should have been a 5-day trial, but your conspiracy took a lot of time for the state to cover.
That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None.
Other than it
At the end of
didn't
the day, clearing away all the
happen.
confusion of the Commonwealth's experts, we're left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither.
They did, though. They did. They unequivocally proved. The Hockomock Sports was still open on the window at 6 o'clock. It was still open on that window. Hockomock Sports. That's unequivocal.
And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That
Mr. No Qualifications, Rick Green.
search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time?
It wasn't user deleted.
When all this suspicious activity was happening at the Albert House and the McCabe house. 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you
Brian Loughran, who couldn't avoid a basketball hoop, but sees everything. Everything.
that there is no body laying on the lawn at 34 Fairview.
Because he
2:30
could
in the morning.
see under the snow.
Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m.
Because he could see under the snow. He's got X-ray vision. Couldn't see the basketball hoop. Has terrible peripheral vision. Couldn't see the screen in the courtroom. But he has X-ray vision to see under the snow. Yeah. Yeah. Can't see anything else. Can't see a snowplow. Changed his story willy-nilly multiple times completely unreliable, but he's got X-ray vision and can see under the snow. Is that why he couldn't see the basketball hoop? He saw through it. The X-ray glasses blocked his vision of the basketball hoop. That's why he hit it. Did he get the X-ray vision glasses out of the back of a comic book? Like, seriously? Yeah, couldn't see the screen in front of him, but he could see under the snow. He could see under the snow. And that's it. He saw nothing. The absence of evidence is not evidence of absence. It was dark. He's focused on plowing the road. Yeah. Is he driving a Franken Lexus now? It's... And that's it. Closing arguments aren't evidence, but can still, they can persuade you. Of course, we still have the state. We still have Lolly to give his closing, which won't be speculation and conjecture and accusations. Well, wild speculative allegations of everyone else. Is he going to get to Colin, or has he settled on it was Chloe and Brian Higgins? But what incentive does Jen McCabe have to protect Brian Higgins? Like, seriously. If you're Jen McCabe and you see Brian Higgins murder John, what incentive do you have not to call the police and say, yeah, so this DEA agent, Brian Higgins, just murdered a Boston cop and did it right in front of me. You should maybe come and arrest him. It's bad. Because Jen McCabe wasn't friends with Brian Higgins. What incentive did she have to protect him? Like, protect Colin, yeah, sure. They're family-ish. I mean, like, my cousin's wife's adopted cousin was a year behind me in law school, and he's, like I said, adopted, a different race. So I jokingly say, yeah, my cousin's a year behind me in law school, to classmates, yeah, he's my cousin. And it's like, that's roughly the relationship between Allie McCabe and Colin Albert. Although they're closer, I knew of this cousin, but hadn't actually met him before law school. But Brian Higgins wasn't a fake cousin, an honorary cousin, an honorary nephew. And that's it. Why would you murder someone in a house with 20 people in it? Unless they all wanted him dead? Like, wait for a better opportunity. It's the conspiracy is stupid. It's absolutely stupid.
And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered.
No. No. Because number one, only the blind simpleton testified about the Ford Edge. I don't believe it was there. Not at all. Identified as a Ford Edge because the defense investigator pointed at a Ford Edge, did a lineup of one, and said, yeah, was it one of those? But he testified it was like offset from the front door by 3 feet, even though John was like 30 feet. So you say it obstructed view of John's body if it was there, even though it was 25, 30 feet north. Great conspiracy you've got there.
Who's the only person in this case that you've heard about with Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence.
With
and that
no
side fence
evidence,
is easily accessible to the front
no
yard,
drag
the side of the
marks,
house.
no
Which
foot
side of the
marks.
house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car.
And why is she setting up an alibi, making up a fictional drive back to Mansfield, making that fictional 21-minute drive in 9 minutes in a blizzard?
Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing.
I just dropped him off with his friends, and he's ignoring me when we're in a fight, and I just dropped him off with his friends drunk. That means he's fucking someone right now. He's upstairs, even though, you know, the sisters from Aruba aren't there. But I'm mad that I just dropped him off with his friends and he won't answer my calls.
Down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, we quickly learned what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught. She reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard.
And she drapes herself across him and calls it first aid.
You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times.
Sounds like she's a crazy bitch.
It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight.
With absolutely no evidence that that's what cracked it, because, there's no taillight there. The taillight's already missing. It's not on the snow in the driveway. The security camera shows it's broken. The Ring camera shows it's broken. But no damage to John's car. No trail of taillight through the snow. Like, did she back into John's car? 5:07. Back into John's car, break the taillight, and by magic, the taillight fragments end up underneath all that snow over at 34 Fairview. Remember, the taillight fragments were found under all the snow. There was already 6 inches on the ground at 34 Fairview when they arrived. 18 inches of snow by the time they were digging it out. But her barely tapping John's car and not leaving any taillight fragments, that's what explains it. Or it, could be she was trying to set up an alibi. She knew she had a broken taillight and had to come up with an explanation.
Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth?
Yes.
The Commonwealth continually tried to tell you that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost...
No. That video did not show that it cracked her taillight. You lying sack of shit. It did not show that it cracked her taillight. We would have required the opposite view to show it cracking her taillight. We didn't see the taillight as she tapped John's vehicle. We didn't see the taillight. We saw the taillight as she drove off, but once again, where are the pieces? Where are the fragments? Where's the trail of taillight? It's at 34 Fairview. You lying sack of shit.
An audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move.
Objection! You heard an audible gasp in the courtroom. That's not evidence, you prick. That's not evidence.
I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level,
it's broken. It's broken. You look at it, there is a piece missing. There is a piece missing. It should be the vertical section should extend more towards the center of the car. It doesn't. It's broken. There is missing plastic. There is missing plastic. And that missing plastic is not on John O'Keefe's driveway. It's not there.
level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged."
Yeah. Yeah, that entire horizontal piece was there. It was, we saw, like, the photos in the Sally Port, it was broken, a bunch of it was missing, but even of the broken lens, there were still pieces hanging on. But the Dighton police officer, it was broken. There were pieces missing, but it wasn't completely broken. That's what we saw. Like I said, the entire horizontal lens is there. So you say the tail light. What do you mean by tail light? Just that one individual lens or the entire tail light? Because yeah, a bunch of the tail light wasn't even damaged.
Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that.
No,
That's
it
what
didn't.
It looked like
No,
before
it
Trooper
didn't.
Proctor had access to the SUV. And you have an independent police officer telling you so.
No, you didn't present these photos to him and say, what did it look like? You're lying. You are lying. He did not testify that's what it looked like because you did not put this picture in front of him. You lying weasel.
You'll recall that after John's body was discovered, Lank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. Which
is standard practice. Not for this case, it's standard practice.
But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely.
No,
And the case was assigned
from
to one
investigation.
Michael Proctor.
And he says the Canton Police Department was recused. They recused themselves voluntarily from interviews.
Have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades.
No. Julie Alberts and his sister went back. Brian Albert didn't know him. They weren't friends. They didn't go back decades. And once again, they didn't handpick him like you said at the beginning, you weasel. You weasel. He was the one who was on call, and the schedule had been set long before. It's ridiculous. I'm not rewatching. This is my first time watching. This is my first time watching.
At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still,
they didn't, though. It was, well, can't remember if it was Julie. Someone can't remember about the gift, but there wasn't a gift. There wasn't a gift. It was, you know, it's the it's just human nature. By the time the gift was suggested, they the harassment had already started, if I'm remembering correctly. So
you've got to imagine that the Alberts had to be stressed. What with that whole thing about a dead body being on their lawn?
what
That might
with
get some attention, and they had to be wondering,
the
when he set up the
harassment?
crime scene, is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every
Even though there was no probable cause for any of those searches.
single one of those questions resoundingly. Nope. He's a Boston cop too.
No,
And with that,
no, he didn't say he's a Boston cop, so I didn't search him. There was no probable cause. Did you forget what probable cause is?
Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A
Fuck
wall
off.
that you can't scale. A wall that Karen Reed certainly couldn't get over. a wall between us and them, a place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody, an outsider. This is gonna be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit.
Except it's not, and evidence is constantly changing. Like the Frankenplow driver.
If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the toe time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene.
And then they had to tow it from Dighton. And the search team was on scene before they found anything. There was no opportunity to plant things under 18 inches of snow, you muppet.
But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide.
But the car arrived at the Sally Port not at 4:11 or 4:16. It was after 5, and the search team was already at 34 Fairview.
By those falsified affidavits saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lockridge? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor.
How did he hide the simpleton? How did he hide him? By not interviewing him? That's hiding him? What? What? They hid him. They were so scared of his ever-evolving testimony that they hid him. They hid him so well that you could find him and get 3 different stories out of him, that you could meet with him at Courtney Proctor's school to intimidate witnesses. They hit him like that. Like, they hid him? Like, did they send him on vacation? Did they put him in witness protection? Huh? How do you hide a living human being? for 2 years, 2.5 years. How do you hide him? I mean, I knew I was going to be upset by little Alan Jackson. I didn't realize I would be broken by stupidity. That's the one I meant to click on.
Was informed that the plow drivers were out that night, there would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta
couldn't
expressly
see
told Michael Proctor
anything.
that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid it. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly.
I mean, Chloe is in witness protection. Loughran is in witless protection. Good job, Dante.
On the additional physical evidence or some additional physical evidence presented by the Commonwealth in this case, you'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to.
I'm afraid I can't take credit for it, Jennifer. Just applying it to Loughran, but witless protection has been used before. It's not my invention. So, yep. No more free pizza for him.
To get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who.
What? What? Like, now you're just making up evidence. Now you're making up evidence. Michael Proctor had an exact match for that glass. Where? What? There's nothing in the evidence about Michael Proctor having glass anything. Sanction him. Object. What? But the jury still hears it. The jury still hears it. If he's making up evidence, you need to object to facts, not an evidence. What's this alleged glass that Trooper Proctor had? It's generally you don't object in a closing, but if you're making up testimony, if you're making up facts, you absolutely have to object. You have to. And the judge may overrule it, but, well, I'd say you want to preserve it for appeal, but frankly, the prosecution doesn't get to appeal because, yeah.
Who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math.
There is no
That leads us to
math.
the magic hair. The
Garbage
Commonwealth spent a
in,
lot of
garbage
time
out.
bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from someone.
So ignore the evidence because it doesn't matter. Our speculation matters. Our inventing Trooper Proctor having glass to plant, pay attention to that. Ignore the evidence though, because it doesn't matter. Little Alan Jackson, you'd think he'd know this because with that hairpiece, he's obviously lost a lot of hairs. But when hair is wet, it sticks to things. Blizzards are wet. Blizzards are wet. It would act as glue, holding the hair to the paint, to the car.
Somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it.
And yet, John's DNA being all over the car, ignore that because you'd expect it. You'd also expect, DNA from the people that beat him to death, but it not being there, just ignore that. Just ignore that. Just ignore that, there's none of Brian Higgins' DNA under John's fingernails. Just ignore that Chloe's obvious bite marks left no DNA. I mean, how could it leave DNA when the light hoodie, it acted as a barrier against the DNA. I mean, it didn't collect any of the DNA itself because, they swabbed that and tested it for dog DNA. Ignore that there was no DNA evidence that you'd expect from a fight. Ignore all that. Ignore the expected DNA evidence because, John, they had sex over every inch of that car. So you'd expect all the DNA. Don't use a black light on Karen Reed's Lexus. It's gross.
Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. No tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about—
Once again, you're assuming it's only 1,000 pounds of pressure, well, it's 1,000 pounds of pressure because it could only be a direct strike or a side swipe. even though it was on the corner of the car. So not a direct hit.
The evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video, much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it.
Or way back in the Stone Age, when they set that camera up, they put it up in mirror. They, like, if the timestamp is in the right orientation, it's probably because that's how they pulled the video.
Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same? Or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent.
As if we're stupid. His words, not mine.
It's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter.
Like
And when they're
you.
caught, they just excuse it away.
You.
Doesn't matter. It's the same
You.
thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for.
No, it didn't say they were searching for naked photos. They never once said they were searching for naked photos. In fact, in testimony, they said they weren't. It was a joke. Those texts were obtained through corruption by the feds at your behest, at Mr. Reed's behest, at whose behest? Those, and once again, let's pretend they were searching for nudes on the phone. Let's pretend they were. Does that invalidate evidence? Does searching for nudes of Karen Reed invalidate the evidence against her? If they had found nudes, would they have been on her side? Like, oh, hey, look, I like this nude I just found. Therefore, let's frame someone else. Like, even if they are searching for nudes, which they weren't, it doesn't invalidate the evidence. It just makes him a sleaze. Being a sleaze doesn't mean you're dishonest, doesn't mean you're corrupt. It just means you're a sleaze. I mean, Did Harvey Weinstein look up nudes? Did he make actresses audition in the nude? You know, would you have liked us asking these same questions about Harvey Weinstein when you were defending him? Ugh.
You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney.
Their search was limited to like immediately where they found John. The scene was covered in snow. The scene was covered in snow. Using the leaf blower, that was literally a 6-foot squared right where they found John. The taillight fragments were found under the snow in a different place. But because the CPD immediate search didn't find anything, it means nothing was there.
Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. And they even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene. Not a single piece. But incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would.
As they dug under the snow. None of it was at the scene. I mean, they didn't clear all the snow. This is why we bring flamethrowers to the scene now.
End up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony to be heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats.
That he couldn't. Others could.
Big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that one red piece was found about 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence.
I mean, somebody's taking liberties. Okay, let's back up. Not into John's Traverse, but close. He's trying to say, well, the taillight was broken, but it was cracked. It was still intact. It was just cracked. As the Dighton officer testified, even though that's not what he said. But it was just cracked. And so we found 3 pieces on the scene that mysteriously became 5 pieces. They were cracked. They were cracked. The 3 pieces became 5 pieces because when they were found, they were 3 pieces that were cracked. They're taken out of the snow that once again, the ice, the snow could have kept it together. You take it out of the snow, put it in a bag, comes apart at the crack. 3 pieces become 5. That's not evidence tampering. That's not evidence tampering. That's not changing evidence. They were cracked.
These bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lally questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened.
Taking the embarrassing screenshots there, the embarrassing pause faces, true crime day deduction. Good job.
He quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes.
Because it was broken, it was cracked.
Multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, but now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what?
6 of those weeks were disproving your conspiracy theory. You're blaming the Commonwealth. You're blaming the Commonwealth for wasting the jury's time. As I've said, this should have been a 5-day trial. It took weeks disproving the conspiracy theory. This is why you don't debate with people in bad faith. Because Simon Dan has said many times he won't debate flat earthers because, frankly, he's not debating facts. But also the gish gallop of nonsense it takes for the bad faith person to spew, it takes 10 times as long to disprove that gish gallop of consciousness. And it's, watch Artie's Corporate Fiction when he's had discussions with Paul Enslaved, or with trying to think of the Moors he's had discussions with, because I don't think it was Jamal, Rise of the Moors. Can't remember who it was, but it takes him 10 times longer to disprove the stream of nonsense. And by the time he's disproved one, they've already spewed out another stream of nonsense. And yeah, it was Sabir. That's who it was. Thank you, Lisa. And yeah, Paul Enslaved is he's nuts. So with little Alan Jackson saying the Commonwealth has wasted all of your time, it's because the defense has spewed this gish gallop of nonsense of accusations with no evidence. You know, it was Colin, it was Chloe, it was Higgins, it was the evil mastermind Jen McCabe, it was Courtney Proctor, it was everyone but Karen, both individually and as a group. And so what should have been a 5-day trial turned into an 8-week trial because it takes longer to disprove nonsense than it does to make nonsensical claims. It's yeah. You watch. I try not to watch Kent Hovind, but you know, watch Creaky Blinder or Simon Dan or Sir Sick. With Matt Powell, the Kent Hovind acolyte. And PhD Tony is a smart man. I mean, obviously, he's a smart man. He's PhD Tony. But I'm you know, I mean, I'm not a debate bro anyway, so you won't catch me doing it. Watching Artie debate Sabir gives me anxiety just because there is so much nonsense in it. Artie enjoys it though, so you know, go Artie. But I'm not going to argue, I'm not going to debate the shape of the earth because it's a proven fact. It's a bowl-shaped earth. I've got evidence all around me. You know, some people tell me, oh, it's just because you live in a valley. But it's my lived experience. I still need to make that parody video. Should have done it a month ago because, like I said, the snow at the top of the mountains, it's a margarita glass, salted rim. But basically, there is no point. There is no point to debating them. So, and like I said, Artie enjoys it. I'll watch his next stream when he's laughing at morons instead of laughing at morons to their face. Just like I said, it gives me anxiety. But part of that is the bad faith element because it's like, to be a debate, you have to take turns. You can't be shouting to each other down. And so it's not actually a debate. But Vince, did you time that squirrel chase? I'm surprised I haven't seen it. But yeah, so the waste of time boils down to is the defense's fault.
It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What
Yeah.
evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite.
Except for
John went into that
all
house.
their
That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. Because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow.
Oh, fuck off! Character assassination? Character assassination. Little Alan Jackson, with his "I'm mad" face, talks about character assassination? Character assassination. Like, this would have been a perfect opportunity for the cameraman to zoom in on Jen McCabe sitting in the gallery. Character assassination? Like you did to Jen McCabe, like you did to Colin Albert sitting next to Jen McCabe. Character assassination. Following the evidence to your client is character assassination. Character assassination. But all that character assassination you did that doesn't matter. That doesn't matter. Has he been tarred and feathered yet? I'm hoping.
Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth.
You wouldn't know the
Concerning John's
truth.
injuries first. The Commonwealth
He wouldn't know the truth if it was a 5-foot dildo slapping him across the face.
own medical examiner, Dr. Scorti-Bello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident.
But also not inconsistent with an auto pedestrian accident. There's a reason she said undetermined.
That by itself is reasonable doubt.
No, it's not. Let's see. We're at 5:26. Not quite. We're approaching the hour. I've been going longer than an hour. But that's because I chase squirrels. And yeah, both sides say it's a homicide. Like, the defense's whole argument is it's a homicide just by someone else. So the medical examiner saying undetermined, that's undetermined supports your theory of homicide, but undetermined doesn't support the Commonwealth's theory of homicide. Got it. Got it.
The evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where
Not a medical examiner. Not a medical examiner. Did one study on animal attacks that was completely different, like zero relevance. As she said, she studied the worst of the worst for that. But, you know, because she studied the worst of the worst, she can tell this was a, you know, little nip from a one-jawed dog. Got it.
he was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation.
Because, yeah, we're supposed to believe Darth Weezer, the medical examiner with dementia.
In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rin.
Who, two of the most highly qualified, they were given garbage inputs. They were working from a faulty set of assumptions to start with. Their testimony was binary. It was, oh, either he was hit full force, dead on, 1,000 pounds pressure, or a side swipe, which couldn't have, you know, imparted any energy, wouldn't have sent him flying, period. But he was hit by the corner of the car. He was hit by the corner of the car. There's a reason the taillight that wraps around is the part that was broken, not the vertical behindy bit. It was the roundy bit. I'm using childish words there so that little Alan Jackson can understand. It was the roundy bit going around the back corner of the car. He says, oh, 1,000 pounds of pressure or nothing. But let's say it's 80% side swipe, 20%, you know, backward momentum. It's that whole angular momentum thing. Not a physicist, but angular momentum. It's a tangential hit. Not a physicist. I can't give you the math. I realize it wouldn't be, 20% head on, 80% side swipe. Full head on would be 1,000 pounds of pressure, therefore 20%, 200 pounds. Can't tell you that. Can't tell you that. Probably isn't. Like I said, not a physicist. But let's pretend. Let's pretend that that's what the math would be. He takes a 200-pound shot, 200 pounds of force to the arm, and the arm is, you know, the upper arm, elbow against his body, forearm extended so that his hand with the drink in it hits the other side of the taillight, and that provides the spinny bit. You know, once again, nice childish words for little Alan Jackson, so he'll understand. that 200 pounds of force could have thrown him. You know, the whole 30 feet, that's we don't actually know how far he was thrown. Could have thrown him a bit. Then he stumbles because he's drunk. It's wet. It's slippery. Little Alan Jackson may not realize this, but snow is slippery. Snow is slippery, especially when it's like half an inch. Like, for those of you who don't know, walking in the snow with a robot leg is kind of difficult. But there's different types of difficult. Like, if it's under an inch of snow, I have to be really careful because it's real easy to slip and it hurts like a motherfucker landing on a stump. Even if it's encased in carbon fiber, because then that pressure goes into your groinal region and that really hurts. Whereas if it's a foot of snow walking through, you know, I'm not slipping. Of course, I'm not stepping over it because, once again, passive hydraulic knee, it's impossible to take high steps. But I'm not slipping. So, based on the evidence, there's between half an inch and 1 inch of snow, because we figured it to be roughly an inch an hour through the storm. It's not a constant rate, but it's been pretty consistent, inch an hour. So 200 pounds of pressure sends him flying a bit, stumbling a bit, falls back, hits his head. And, you know, the expert, when asked, well, if he hit his head against the frozen ground, wouldn't that be a solid impact? Oh, I couldn't possibly testify about that because I don't have enough information. I'd have to know the freeze-thaw cycle for the weeks before, and I'd have to know all of that. I couldn't possibly tell you that if the ground's frozen, it could fracture your skull. Couldn't possibly testify to that. But, you know, I don't have to take all the variables into account to tell you he wasn't struck by the car, because, you know, it couldn't possibly have been the corner that hit him, even though that's what the evidence shows. It was either a side swipe or head-on collision. I have enough information to tell you that. Dead certain. Can't tell you about the frozen ground, though. Can't even speculate that the frozen ground could fracture a skull. But, I mean, that expert's witness was absolute garbage.
Finchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing. They did analysis. They evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony.
Who sucked?
I think I'm being kind when I say that Trooper Paul's analysis lacked credibility.
But so did the ARCA experts. Trooper Paul sucked, but the ARCA experts sucked too. They were just better at testifying. They both sucked. They both had garbage, faulty assumptions. The state should have got a better witness. They should have got a better expert. Trooper Paul sucks and needs a different job. He should run speed patrol. He sucks. But the thing is, the inputs for both sets of experts were assumptions. If the inputs are garbage, the output is amplified garbage.
Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the...
Once again, that's Trooper Paul. The jury can make reasonable inferences. As I've said, my reasonable inference is it's not the taillight shattering that caused the scratches. It was the dimpled taillight causing the abrasion as it moves across his skin. Mostly, it's the side of the taillight, the side of the SUV moving across the skin. And Vera, thank you for the gifted membership. I always appreciate your support.
The left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body.
Like maybe it was
It's
in his
nonsensical.
back
It borders
pocket.
on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-reviewed articles on the issues. Both
And thank you again, Vera. I still appreciate your support.
men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did
And
Dr.
yet they
Rentschler say before he
still
left the stand? This is
sucked.
even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't.
But they were given by the corrupt FBI faulty assumptions to put into their calculations. Dr. Rentschler, was very happy to speculate about how John was hit or not hit, conveniently leaving out the glancing blow, the tangent, what was I calling it yesterday that Vince was making jokes about? Didn't even consider that. Just took his garbage assumptions, garbage inputs from the corrupt FBI. But can't even consider the fact that in a blizzard in January in Massachusetts, the ground would be frozen solid. So therefore, John must have, fractured his skull on the curb or on the pavement and then got up and gone over to die. The ground was frozen. It was January. It was a blizzard. But but Rentschler couldn't even consider that the ground would be frozen because that's what he didn't have enough information about. He had to consider the weeks before. But even when confronted with, you weren't given this piece of information? No. You weren't given this? You were given incomplete data by the corrupt FBI? Yes. But you still stand behind your conclusions off of the faulty data. Oh, yeah, sure, it doesn't matter. Only with the frozen ground did he need complete data. Only for that. And we're supposed to think he's a credible witness? Seriously?
Hit by that car. Period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero.
It doesn't turn to concrete. It's hard as concrete. I realize little Alan Jackson from LA may not understand this. The jury does. The jury is from Massachusetts. They have been in blizzards. Like, there's zero evidence it turns to concrete. No shit. No shit. You can still crack your skull on it. Concrete isn't the only skull cracker.
They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back.
You take a blow to the head, you bite your tongue. How the hell else do you think you lacerate the tongue?
To the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump.
Other than all the injuries.
Not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour.
Other than the injuries to his arm, the injury to his knee, the injury to his hand. He was pristine from the neck down. Other than all the other injuries. Other than all the other injuries. And once again, it's that oblique tangential blow. 7,000-pound SUV at 24 miles an hour provides 1,000 pounds of force if it hits you head on. If it hits you head on. The recipe for ice is a difficult one, Frank. It is a difficult recipe. It probably is. Like, little Alan Jackson didn't lose his recipe. He never had it because it was in the advanced cookbook for morons. No bruising, but he died in the cold. No bruising, but he was bit by a dog, and the dog bites didn't cause bruising. No bruising other than the bruise on his knee.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision,
Fuck off.
a whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself.
Maybe he scratched his own nose. There's no evidence he scratched his own nose because they checked his fingernails. Fingernails unbroken, no tissue underneath it, no defensive marks in the fingernails. Casey, you could have had a different Foreigner song in your head when we were talking about the blind as a bat snowplow driver. You know, could have had double vision. I realize it's probably cold as ice at the moment, but you could have had double vision in your head a little while ago. Fun is one word for it, delete lulls. It's one word for it. I have a feeling we'll get through Lolly much faster than we'll get through Little Alan Jackson. So there is that. And yeah, I need to get in on this 250 grand whack racket.
His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that
Festering malignancy. Yeah.
continue? And the answer should be not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He
Oh,
reduced her
fuck
to an
off.
object and went further by insulting her.
I don't even have it in me. I gleefully did with Trooper Proctor on the stand. I gleefully shouted those things at him. He was gleeful. I don't even have it in me. I don't have it in me. I'm pure as snow, Little Alan Jackson. Not that he knows what snow is, because he, once again, lost his ice recipe. But he doesn't have it in him. Oh. Someone put a chair behind him just in case he faints thinking about it. Oh. He might swoon. He might swoon. And delete lulls, he does take after your namesake when it comes to pause faces.
Further than insulting her and dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That.
And by then, as he testified, the harassment campaign had already started. The hoping she would end herself, the harassment campaign had already started. Like, oh, he erased her humanity. He erased her humanity. He had already seen all the evidence that she was a murderous Karen. He erased her humanity. She'd already spearheaded a harassment campaign against his friends and family and co-workers, and he erased her humanity, led a smear campaign against an innocent woman. Say this, turn around, little Alan Jackson. Say that to Jen McCabe's face. I dare you. I dare you. Turn around and straight to Jen McCabe's face say how the prosecution's witnesses erased Karen's humanity and led a smear campaign against her. Do it. Turn around, say it directly to Jen McCabe. You weasel.
That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about, top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment?
Convict.
Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is...
But that's only if you ignore all the actual evidence and focus on the sideshow circus. Look at the silly monkey. Look at the silly monkey. Don't Don't look over there at the evidence. Look at the silly monkey.
Innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much.
Well, I mean, it is in evidence, and like to counteract little Alan Jackson saying, that Trooper Proctor dehumanized her by hoping she ends herself. If Lolly gets up and says, yes, Trooper Proctor did say he hopes she ends herself, but he said that after the harassment campaign began against him and his family and these fine people over here. Be objected to, but the door is open. It's in evidence. It's in evidence, and little Alan Jackson focused on, I hope she ends herself, giving the reason he said that when he said it. The door is open.
Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor. I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant 4 times.
Yeah, Jackson kind of tried to ignore that. Like, he didn't even bring that up. That they say when making a legal argument, you've got to acknowledge the bad facts. Because if you don't, only your opposition gets to acknowledge them. You don't get to explain them away if you don't acknowledge them yourself. Little Alan Jackson didn't even say, firefighter McLaughlin says she heard my client say, I hit him, I hit him, I hit him. But it was a chaotic scene. Others testified that she said, did I hit him? Could I have hit him? He can't explain that away now. But with Lolly, right out the gate, I hit him, I hit him, I hit him. An admission. An admission. Right out the gate. Little Alan Jackson, there's no evidence whatsoever that Karen Reed struck John O'Keefe. Other than, I hit him, I hit him, I hit him.
You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened. And the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant. The defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Saraf, statements that he attributed to the defendant as saying that morning, "This is all my fault. This is all my fault. I did this." This is what the defendant is saying on scene. Since then, story's changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. I'm going to bring some of those to your attention.
Unfortunately, he can't really comment about the little actions, the little things like Karen showing absolutely no remorse in court, her smiling and eye rolls and laughing and yucking it up as soon as the jury's out of the room.
As I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a three-card monitor. Facts and the evidence in this case are your card, they're the queen of hearts. And so what I want you to, or what the defense wants you to do is not look at that card, look at anything else. Look at.
I like that. I like that. It's three-card Monty, defense by obfuscation. Or, as I put it, look at the silly monkey. Look at the silly monkey. Don't look at the evidence. Look at the silly monkey. It's three-card Monty. Lolly is a smart man. It's three-card Monty. I just use South Park references. Three-card Monty, look at the silly monkey. Don't look at the actual evidence. Look at the nonsense we want you to look at that isn't actually relevant.
Movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court.
Good call.
The evidence and the facts of this case are for you, the jury, to decide. Using your common sense.
Once again, going back to the comment I received. Well, Dr. Russell, the dog bite expert, said it was a dog bite. The prosecution's medical examiner, who actually looked at the body, said it's not the classical signs of a car, being struck by a car, but it's not inconsistent. Therefore, it's beyond reasonable doubt that it's a dog bite and clearly not struck by a car. It's for the jury to give weight. They can decide that Dr. Russell was completely credible and it must have been a dog bite. They can think she was an absolute quack looking to insert herself into the case and get her 15 minutes of fame. She was a paid expert that was paid for a certain opinion, and she delivered that certain opinion. The jury can decide. He's going to say, right after this, you can use your reasonable inferences to put the puzzle together. Something like that.
Using your life experiences as your guide through that as you go.
Life experience, like the frozen ground hurts to land on.
Before I turn to that evidence that I will submit to you and eluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation.
Exactly. It's look at the silly monkey. Those text messages had no evidentiary value whatsoever. None. None at all.
That Massachusetts State Police collectively conducted into John O'Keefe's death. As was asked of Trooper Proctor on cross-examination, These were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom. Put you in a sort of safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence. No evidence whatsoever. Why? Because it didn't happen. There is no conspiracy. There is no cover-up. There is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things.
Yet, Trooper Proctor's friend, like, being skeptical in the text messages, that's evidence of Karen's innocence. At least that's how little Alan Jackson was trying to frame it a couple of weeks ago when he was gleefully using those words that he'd never use. That they shock his conscience too much. But he's a changed man in these 2 weeks because, you know, he gleefully used them a couple of weeks ago.
Things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional. There's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story, from his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here what I'm going to go with from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason."
Hey, I remember yesterday or Friday or someone, I think it was Anne, saying it would be nice to have a timeline. Here's your timeline.
Reason you've been like this. John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not."
If only I had David Byrne as a guest today. Not that David Byrne would slum it with me, but if I had David Byrne today, thinking of the OMG stop calling, the 57 calls, we could have David Byrne sing Psycho Killer. Of course, I'd prefer to have Tina Weymouth playing bass because, oh God, she was great. Yep. Not a difficult bass line to play, but Tina Weymouth is a genius on that instrument.
Not answering, stop calling. The defendant then texts John, then stop starting with him. 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul. Asking to go out for a drink. This is while Erin O'Keefe testifies she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime or strong. 9:13 p.m., drink number 2.
He's steering clear of Canton and any roads that the Massachusetts state troopers have jurisdiction to patrol. Like, he's taking side streets, avoiding Canton to get to the airport and, back to LA.
20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's.
That's 9 drinks in an hour and 56 minutes. And once again, some of these are mixed drinks, presumably vodka soda. Some of them are shots that she's pouring into the mixed drinks. We are assuming that all of the mixed drinks were singles. This is at least 9 drinks, because if any of them were doubles, triples, I mean, doubles aren't allowed here in Utah, but Canton isn't in Utah. So, and the thing is, though, she says she's going out to get drinks at 3-ish, but we don't have evidence of where she was drinking or what she was drinking or if she followed through. So when I say at least 9 drinks, that's what's known to us. And yes, the bar receipts are in evidence. The jury has them. We have not seen the details on the bar receipts. We only saw them getting admitted into evidence. The jury has them. The jury will be able to see if any of them were doubles. The jury will be able to see. We don't. So our assumption, at least 9 drinks. And when I say 9 drinks, I mean 9 units of alcohol. So, yeah. And I know, Grey Duck, it's shocking. Minneapolis is in Minnesota as well, just so you know. And that's here in Utah. You don't get heavy pours because Utah. I assume you don't get heavy pours on a shot because, shot. But in the vodka soda, she could be, even if it is a single, it could be a heavy pour. That's a good point, Frank. So, and also, don't drive drunk. It's a scumbag move. If you have 9 drinks in under 2 hours, get an Uber, walk home, flap your arms and see if you can fly. Skate across the frosty ground. Roll down the hill. Don't drive. Don't drive. It's a scumbag move.
She indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testified that she produced from her coat when she walked in. and that you can
Yeah, there's a mill pond right next to the waterfall going in the direction of John's house. Swim. Good point. Levitate. Apparate. Like, don't drive. Don't drive. Of course, as Kevin says, we can assume the Canton Police pregame. Canton Police, drunk driving is a scumbag move. Don't do it. Don't do it.
clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks. What she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Polakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert and Cole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11,
Good point.
Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, where to? 12:14 a.m., based on the fact that she's driving, and Mme. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions or going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17.
Come on. Come on. Bella's mom's house. Well, Bella's house is what was said, but, you know, love of his life, Bella's mom. Give us that. Give us that. Come on. Come on, come on, come on. In the phone call you just mentioned, give us that. CJ5, good morning over there in the Upside Down.
1856, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to coinciding with what you observed the black SUV from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have.
Because little Alan Jackson is a lying weasel, a lizard in a human suit.
That testimony from Ryan Nagel, Heather Maxon, and Ricky D'Antonio, pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area.
Don't you talk bad about paisley ties. I almost exclusively wear paisley ties. The more garish, the better.
Between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. Have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle.
12:25 is the last movement. Little Alan Jackson, Karen couldn't possibly have driven back to One Meadows. It's a 5 or 6 minute drive in the best conditions. But 12:25 to 12:34 is 9 minutes. So, like, in the best conditions, she couldn't possibly have done the drive in, 1.5 times the time it normally takes, even though in her attempted alibi, she can make the 21-minute drive to Mansfield in 9 minutes. She can make that drive in 9 minutes and be back with the niece 2 minutes later when she calls and leaves a voicemail. She can do all that, but she can't make this drive in 9 minutes drunk. Can't do that in 9 minutes. What would usually take 5 or 6. Imposterous, says the little lizard man. But the fake drive to Mansfield, that happened. That wasn't setting up an alibi at 1 a.m. That's not consciousness of guilt, setting up an alibi 5 hours before John's body is found. Grey Duck, you're just telling me this now? You're just telling me now that Mansfield is the location of the portal? Would have been useful to know weeks ago. Exactly.
Movement of the vehicle as it comes down, Cedar Crest passes by Fairview, reverses direction, and then comes down Fairview, moving up, as witnesses described, eventually stopping in that area of the
But there's a reason the defense didn't use maps and charts and timelines. The defense wants confusion. They want speculation. They don't have facts. Facts are not on their side. They put up the chart showing exactly where John was and when. Then they have to argue the actual facts, not their misinterpretations. So, of course, the prosecution uses it and the defense didn't.
property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota tech stream, which you now have up on the screen for you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour, 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event, 8 minutes after the 3-point turn, when the vehicle is in reverse at 24.2.
I mean, there's the old saying, if the facts are on your side, you emphasize the facts. If the law is on your side, you emphasize the law. If the facts and law are both against you, you pound the table and, look at the silly monkey. Look at the silly monkey. Like, seriously? The prosecution has no case, therefore they're relying on the facts. The prosecution has no case, therefore little Alan Jackson doesn't have a face because, it's the human mask. He's a lizard. But the prosecution has no case, therefore they put things in chronological order so that they're easy to follow. As I've said from the start, you may not like the way Lolly has presented his case, but he's been chronological with everything. It's little Alan Jackson that's doing the back and forth timey-wimey nonsense. If the facts aren't on your side, you jump back and forth to try and create confusion. You try to create confusion because a confused jury might have doubts even if the facts are incontrovertible. But presenting the facts in a linear timeline in chronological order, it is part of the cover-up. I'm so glad this case is over-ish for now. I'm so glad we get to move on to fun things for a while at least. Sinclair, good to have you here. You missed the swear counter with little Alan Jackson and him being, too morally outraged to even contemplate the dirty words that he gleefully shouted at Trooper Proctor a couple of weeks ago. Gleefully. The thing is, I get the feeling that DUI guy is 5'9", would be my guess. But it's just a guess. Just a guess. So, yeah, and there were some excellent pause faces that you missed, Sinclair. Excellent pause faces of little Alan Jackson. Most of them looked like he was trying to poop. This case is going to result in new laws, I think. As I've said, I think this case and the Koberger case are the beginning of the end of live-streamed trials. So this case definitely will lead to dissertations and criminal justice discussions, but I really do think it's going to lead to changes in the way courts handle high-profile trials. I really do. Like, the public has a right. They don't have a right now. We'll release everything after. And everything's under seal until after the appeals run out. I think Koberger, well, I think this case has been more egregious because of the sideshow surrounding it. But Koberger, Judge getting so upset with the media, he took control of the cameras himself. And, Gwyneth Paltrow, Park City, the camera operator wasn't following the court orders, and it really upset the judge. And things are going to change. The thing is, they can't go to court like they used to because, the defense asks for the small courtroom. I mean, you can have the overflow, have the live feed only going into the spare courtroom, watch it there. And Yeah. Lawyer, doesn't view bot. He gets the views. He gets the views. So, and that's the unfortunate reality, though, Vince. If live streaming the trials makes it impossible to hold the trial, then they're going to stop live streaming the trial. Like I said, they might not stop recording the trial, putting it on video, but I have a feeling within the next few years, the norm is going to be just release it all after the trial. And, well, I mean, you already have it. We didn't get to watch the Weinstein trial. We didn't get to watch little Alan Jackson in that because New York didn't film it. Federal court doesn't film it. The California, it's hit or miss. Obviously OJ was filmed. Danny Masterson wasn't. We had to just go by the witnesses in court. But I think even in places where the presumption is towards filming it, I think the trend is going to go toward releasing it after. I could be wrong. As I've said, I don't have a crystal ball. If it becomes untenable for courts, because the trial has to come first. The trial has to be protected. And if protecting that trial means not live streaming it, hey, it could happen. So,
miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at One Meadows Avenue, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62 and a half feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. You recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert."
CJ5, I couldn't actually tell you what time the jury got the case. They left for the day about 4:30, so.
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there. She had struck him there. She had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m.
And that would have been a magic drive to Mansfield. I wish Lolly would have said, there's no evidence she drove back to Mansfield. These texts were setting up an alibi. This shows she knew she hit John at this time because she was setting up an alibi at 1:09 a.m. But at 1:11 a.m., she left a voicemail saying she was there with the kids. So she made that 21-minute drive back to Canton from Mansfield in 2 minutes. Or she was setting up an alibi.
She calls Mr. O'Keefe and leaves this voicemail.
John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself.
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning.
With that 4:42 a.m. text, did she light it up just for fun? I'm also a big Primus fan.
Is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, calling your parents, all of these other things.
Alpha, Karen Reed has a big brown beaver, but she pricked her finger one day and realized she might have a leaky balloon knot. Porcupine. I think that's how the song goes.
No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives in Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was.
And she told Jen. She told Jen McCabe at 4:53 when she called, "I left him at the waterfall." And Jen says, "No, you didn't. I saw you outside 34 Fairview." And that's when she changed her story.
Hit him and left him there the night before. She had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe and Ms. Roberts, return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruise camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spot that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant sitting in the back seat of the vehicle knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. The defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone.
I mean, visibility, you know, was different in Frankenplow. For our, you know, blind, colorblind, can't see a basketball hoop, yeah, you know, simpleton.
6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search of evidence. 5:30 p.m. is when the defendant's vehicle arrives at the camp.
What was that look, Karen? What was that look? What was that look? Why were you suppressing a smile as you were giving little Alan Jackson googly eyes? You realize that smile was in the direction of the jury, that they could see you. Why?
Police department.
And remember, the prosecution gets the last word. Like, if she's smiling like, ooh, we've got him here. No, you don't, because you don't get to address the jury again. You don't get to address the jury again. You're done. You're done. Could be that. Could be that. Oh. Brutal. Brutal, CJ5.
So, we circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. We heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. Reed, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. Even blew.
Okay. Remember what I said almost at the beginning of little Alan Jackson's rant. I'm not going to call it a closing argument. It was a lie-filled rant. But remember when he said something to the effect of, by the time they were at McCarthy's and Waterfall, they were lovey-dovey. Everyone testified. They looked like they were a happy couple. They had already made up. They were happy. There's no way she would have murdered him less than an hour later because, you know, in front of their friends, they were lovey-dovey. No problems at all. And, you know, it only takes seconds to, form a motive and get mad at him walking down into the basement at 34 Fairview. But, driving past Bella's house and being reminded that you're only a babysitter with benefits, not enough time to restart the argument you've been having for weeks, that you've been having all day, that couldn't have possibly restarted the argument. But remember what I said. Remember what I said. They were putting on a front. They might have still been steaming mad, absolutely enraged, but they put on a happy smile because they're out with friends. They're putting on a front. To quote The Who, eminence front. It's a put on an eminence front. For the 2 years of their relationship, they've put on a front. Paul O'Keefe and Aaron O'Keefe think she's good for him. They're all lovey-dovey. Their friends all think she's good for him. They're lovey-dovey. Because when they go out, when they're in public, when they're with friends, they're lovey-dovey. It's a front. It's a front. The kids who we didn't get to hear testify, remember, we didn't get to see it. We didn't get to hear it. But behind closed doors, they weren't putting on a front. They weren't putting on a front. Why didn't she leave that abusive partner? Not talking about them, but this is the common refrain. If he was abusing her, why didn't she just leave? Therefore, I don't believe them. But behind closed doors, people are different. People are different. People are different in front of people. It's a put on. It's a put on. An eminence front. And I realize that song is about cocaine, but we'll use it for this. So behind closed doors, it's not a good relationship. The kids testified about it. Good to know. I wouldn't have known that as a fake juror because I wasn't there. So, yeah, it's just.
Blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. Bennett shows up at the house. Abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning, grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drive that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle, or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard.
Evidence tampering.
You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. Heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. Defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dayton. She's indicating over the phone to Aaron O'Keefe, I don't think I'll ever see you guys. Why? If she did,
Like, you're not even expecting to go to the funeral? Like, even if you expect to be cut out of their lives because, you know, John was the connection, like, you're expecting to be uninvited from the funeral? I don't expect to ever see you guys again. But that bitch that he was hugging in Aruba, you know, she and her sister are still in the life, even though John's best friend, who was the connection there, died. You know, connections can survive. Maybe they change, but they can survive the death of the person connecting you. But here it's, you know, we're gone. I'm gone. I'm never going to see you guys again, not even at the funeral, because I killed him. I killed him. Blue shirt with the purple head, with the vest. No idea. He's been there most of the time. I've assumed he's a family member, but no idea. No idea. But I really don't want to think about him having a purple head. That's just gross. And yeah, to me, that's consciousness of guilt. I killed him, therefore I'm not going to be welcome anymore.
you killed John. Why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met, meaning the defendant, Ms. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. Her testimony consisted from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen, based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child.
Yes.
The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes, and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asked him if he's okay, asked him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece, Kaylee, John tried to diffuse, tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had
John attempted to break up multiple times. Really would have been nice. Like, I fully support not live streaming the children's testimony. I fully support it. it would have been nice to have a transcript, to have something. She's a clingy, she's a dingleberry. She's unflushable. She's an unflushable leaky balloon knot.
Run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. But Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code to the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with the father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant
Placed a romantic kiss on him. Placed a romantic kiss. Placed a kiss. She plucked it out of the box and placed it right there on his cheek. I like his phrasing there.
is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts a broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. A variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call Julie Albert. Because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call that both Mr. Albert and Ms. McCabe testified was never answered. As the phone is ringing, her husband, Matthew McCabe, reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a cloud and that he's dead. And then
I would have absolutely lost it. Delete lols. She proffered a kiss to Brian Higgins. Because we know if you proffer something, it's criminal, according to the Free Karen Reed crowd. Damn you.
indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage.
So that's important. Remember, little Alan Jackson, well, the Dighton police officer testified it was like this reconstructed, it was cracked but whole. Not what we saw, even though you didn't put that reconstructed photo in front of him and say, Is this what you saw? Is this how you saw it? He said there were pieces missing. Like, you completely mischaracterized his testimony. But Jen McCabe and Carrie Roberts testified, yep, that broken taillight, that's how we saw it. That's how we saw it. But Jen McCabe is a criminal mastermind with no motive whatsoever. So she'd say anything to frame Karen Reed, who she actually liked before all of this. But, you know, will mischaracterize, like completely mischaracterize the Dighton police officer's testimony. Completely. But Jen McCabe, even before the car ever went to Dighton, testified, yeah, it looked like the broken taillight, missing pieces on the right, not the reconstructed taillight that was cracked on the left. Well, in her brother-in-law's yard, but yeah.
When the search warrant is executed on February 1st. You have the text messages between the defendant and Lord Sullivan from January.
Her rented clothes came out of the leaky balloon knot section.
29th, in which the defendant indicates to Lord Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by defendant, Mr. Gabe Roberts, around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34th Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitfield as the SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of them. Also from Super Marino as well. These searches were unequivocally done at 6:23, 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not.
Remember, the tab was still open on Hockomock Sports at 6:23. It showed it was open when the focus returned onto that tab. It was still on Hockomock Sports. That's unequivocal. And the search, Hosslong to Die in Cold, was made seconds after the focus returned to the tab that had Hockomock Sports open on it. That's unequivocal, unless you're a moron.
Deleted by user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whitfield, had to alter exactly how their software works because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those.
So you're aware that your misinterpretation caused them to update their software? Yes. So it's in it. So you're admitting it was a misinterpretation.
Questions as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. He knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. With each of those first responders indicating is that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay? How is he? Any sort of questions about medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18, 5:35. The repeated questioning, firefighter Whitney, firefighter Woodbury, asking Ms. McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. And she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other, really at all. The only time, as they both testified to, that they ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Alberts said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, she's going down Fairview or coming off of Chapman. If you first go down a big steep hill, it flattens out for a little bit, and then you go down a second, 2 hills going down on Chapman, matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. She's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before, and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction.
Gonna
But
mention
she's giving
Bella?
directions, and she indicates that she uses a house that Mr. O'Keefe would be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so fresh on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Ms. Roberts and Ms. McCabe in Ms. Roberts' car. She's still talking about it at that time. It's that much on her mind.
Please say babysitter with benefits. Please say babysitter with benefits. Bella's mom was the love of his life.
Ms. McCabe indicated that she looked out and she saw a vehicle initially in front of the front door as Mr. McCabe, as Brian Albert Jr., as Julie Nagel, as Brian Nagel, and the vehicle moved up several times for several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts. And then moves up further beyond that. And I say that in the sense that it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing what the defendant brings up her cracked tailbone. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule. pretty strict rule in this house as far as you take your shoes off when you come in the house. So what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots
Karen knew it wouldn't matter.
In the mudroom, and then they walk. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home because she hit him with her SUV and she left him in the snow. Ms. Roberts?
I mean, I know a few people that if I did that, they'd haunt me. But, you know, I don't think John is the haunting sort, even if he is a neat freak.
Ms. McCabe, frantically sort of running around the house looking for Mr. O'Keefe, and it's not. They then get in the vehicle, they drive back towards Fairview Road, and again, the defendant from the backseat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight.
Have fun with BSBT. I tell him to, you know, turn himself in.
Straight over to where Mr. O'Keefe is laying on the front lawn. You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting resuscitative efforts trying to save Mr. O'Keefe's life. Ms. Roberts indicated that she observed underneath only the phone, but the phone on the grass in the area that is completely covered in snow in every other area except.
No idea, William. She's been there the whole trial, but frankly, I don't know.
Under Mr. O'Keefe. So I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and starts to stick a little bit.
Inch an
You heard
hour.
all that testimony. And I know it was a lot of testimony about snow, a lot of testimony about weather, but there's a purpose to that. There's a point to that. Okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, it's still visible only under Mr. O'Keefe where his body is. So I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose of that as well. If you look at this, if you look at the video of the defendant.
Yeah, you want me to do it, you've got to give me a chair and a shoehorn when I leave.
Crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video, you see the damage consistent from the 822 video, from Lieutenant Ray, from the cruiser camera video, who's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent.
Yeah, I forgot about Lieutenant Ray's video. I forgot about that one. Because that was a very clear view that the taillight looked like we saw it. I forgot about that one. Lieutenant Ray's video at 8 a.m. when he went to check on the kids, do the wellness check. The taillight wasn't just cracked, it was missing. It was broken at 8 a.m. They didn't steal the pieces in Dighton. They didn't steal the pieces in the Sallyport. It was clearly broken in Lieutenant Ray's dash cam at 8 a.m. You can almost tell he's prepared the closing argument. I didn't. He remembers the evidence.
On the right here, February 1st, 2022, when the search warrant is conducted, Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. Magic hair, as Mr. Jackson likes to call it. So the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow. And Officer Barrow saw it in the driveway in Dayton as they were wading through 1.5 feet of snow.
Frozen to the vehicle. Little Alan Jackson in LA would call that magic, but frozen, caked on, not magic.
Walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair.
Yeah, look at that. Look at that. And this is 8 a.m. This is at Johnny's house, not Dayton. This is from Lieutenant Ray's dash cam. The horizontal liftgate lens is solid. The quarter panel vertical lens, the roundy bit, to use words that little Alan Jackson can understand, the roundy bit is broken. It's broken. See how there's snow inside the cavity there? But oh wait, look at the left side. The roundy bit is solid, unbroken. Unbroken. I don't know. I think frozen is a little bit above little Alan Jackson.
Was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes,
And we're
after
too
it's been in
small.
there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit. Weather was wet. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans.
Don't
You
forget
heard
the
also
belt.
testimony from
And
Ms.
1,
Roberts
2.
in relation to the injuries she observed. Mr. O'Keefe, that's initially on scene. There was one eye that was swollen, not the other. That's indication of the swelling that Dr. Sportibello was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony, to medical testimony, to forensic testimony, to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarif's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarif. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body.
Yet, Mr. Can't see a basketball hoop in front of him, could see him driving by. Karen Reed, in her frantic state from the back seat, could see him as they drive by. But the police officer walking up to him, specifically looking at him, couldn't see him until he was 5 or 6 feet away.
There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that, to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave.
Oh! Okay. Criminal genius mastermind that Brian Albert is. 34-year veteran police officer, criminal mastermind, just leaves the body on his front lawn. That'll fool him. Let's listen to that again. Let's listen to that again. Oh my God, that was good. Oh, that was good.
To then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn. Really?
Really? Wow. That sums it up. That sums it up. Really? Really? Even a drunk cop knows the best cover-ups involve leaving the body on your own front lawn. Really? Really? Oh, that was good. Really? I realize I'm just quoting South Park again. You know, Kyle, really? About the 9/11 conspiracy. Really?
That's a conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfront. Same testimony that you heard from Ms. O'Keefe, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they were left the waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2020.
Last night, not being 5:07 a.m., backing out of the driveway. It was already broken last night.
22. You have that other reporting of that other version that she now has evolved into as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that?
None.
Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never.
But that just means they're all co-conspirators covering it up. And so is Verizon, since John O'Keefe's phone never went in the house. And Apple. Crapple. And Waze. And, you know, everything else. Everyone is in on the conspiracy. Remember, the Bushes are in on the conspiracy because they're members of the Skull and Bone Society, and John had a fractured skull. The Pope is in on it. Can't remember why, because that was weeks ago, but the Pope is in on it. I'm in on it for some reason. Everyone is in on... Yeah, the Roman Empire Can't forget the Roman Empire is in on it. Can't remember why they're in on it either, but the Roman Empire is in on it. So everyone and everything is in on it, except Karen Reed. Even little Alan Jackson is in on it.
Never went in the house from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Cole Albert, Brian Higgins, all indicated in the testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a three-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet.
But the defense will have you believe, even though they don't see anyone get out of the vehicle, because they didn't see John as they were driving by, not paying attention to it, because they didn't realize, how stupid are they not realizing they'd have to testify about it 2 years later? I mean, come on. I always pay attention as if I'm going to testify 2 years later to everything. I'm alone in the bathroom. I'm ready to testify about it 2 years later. I take notes. I take video. Don't look at my OnlyFans. It's gross. But they're not paying attention. They're not looking for John, but they don't see him. They don't see anyone get out of the truck. They don't see anyone get out of the Lexus. But, somehow he's left. Somehow. Maybe. How? Maybe John should have taught Karen how to apparate so that she wouldn't have to drive drunk. Maybe he did teach her. That's how she traveled from Dighton back to Canton in 2 minutes. Maybe.
At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? Dome light comes on. So there's a reason I would submit, for the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle.
That's a good point. I hadn't even considered that. I just thought, switch the dome light on because you're fighting. But that's a good point, Lolly. That literally could be the moment that John O'Keefe is stepping out of the vehicle. You see the dome light on because that's when he opens the door to get out. And Karen, literally, they drive off and Karen strikes him under a minute later. It doesn't count because you didn't say it here. And if you did say it here, it doesn't count because I don't remember you saying it in chat. But yeah, that's a good point by Lolly. I like that.
And then they're gone. The Nagels, Brian Nagel, Ricky D'Antonio, and Heather Maxson drive away from that. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 30.
John really died of a peanut allergy, so Jeff is in on it.
Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. The testimony recalled when you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time, 12:10 a.m. We have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza, what are you doing later on, contained within those texts. You have testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic.
I imagine this would have been a difficult day for him. Like, obviously, I don't know either of them. I have a feeling Mrs. O'Keefe, like, it's been rough on her, obviously. But I get the feeling she's just that little bit stronger than Daddy O'Keefe. And you know, my heart just breaks for both of them and the kids and the siblings and friends and everyone.
About those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road.
And it would be very difficult to plant evidence at ground level underneath 18 inches of snow without disturbing the snow in order to plant it.
We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. We heard testimony regarding the defendant's blood alcohol concentration from Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. You have the witness testimony in the surveillance video in regard. The forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, the clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone at any point in time ever said Mr. O'Keefe's arm was out like this at the time that he struck and then he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches to the tailbone. Is easily solved by this. And the dimples on his arm are, that I would submit, are consistent with the dimples on the taillight cover piece, are right around this area of the elbow.
And it's those dimples not hitting, it's rubbing past.
We have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight house, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have testimony from Ms. Hartman to recall as regards to the damage that they observed, the dents, scratches, 7/8 of an inch hair. You have testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes. All consistent with pieces of taillight that are found within his clothing.
1 minute. So
Ms. Gilman, if I could.
1 minute. So let's have a big dramatic pause.
6:05. This is what this vehicle looks like backing up at that speed for approximately that distance. There's another years and years ago. Started practicing in Norfolk County, in Braintree, what is now Quincy. Eventually became a far smarter man than myself. Eventually became president of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing his death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right, thank you. Jurors, I have my instructions on the law. I'm going to give you, my guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
It was one sentence with a semicolon.
You are muted.
I have a feeling, even with the nerves, Karen still felt a bit of relief, like, well, nothing else you can do. It's done. Like, there is a different type of stress waiting for the jury, but being done, that's one stress lifted. That's one stress lifted. And I'm just going to say it. I don't want to do the jury instructions. I don't have the patience to do that today or tomorrow, frankly. I don't. It's boring and we don't need it. So, we do have, though, that. We do have that. My verdict. I've promised you from day one, I would not give my verdict until after both sides have given their closing statements, closing arguments. Because it's inappropriate. So, you may remember all the way back day one, well, day zero, because it was my introduction to the case. I said, go ahead, put your verdicts in. As I filibuster, go ahead and put your verdicts in. So day zero on my introduction to the case, I said, I have done my best to avoid evidence so that I only decide based on what's presented in court. And I said, my gut is that she hit him. But I had no idea on intent. I didn't know the evidence for intent. And basically, I shifted one step over in the trial. And I'm with CJ5. DUI manslaughter. But my gut instinct is that it was murder too. Like, in my heart of hearts, I believe she intended to. Now, if in the jury instruction, there's an instruction that failure to render aid when required would make it murder too, if that's in the instruction, that would raise my ultimate verdict to murder too. Because the general rule is you have no duty to render aid. But if you caused the need, basically, for the aid, you then have a duty to render that aid. So if there's an instruction that failure to render aid makes it murder too, then that would be my verdict. The Bella's mom and the fighting and, you know, the Aruba makes me think that it probably is murder too, but I'm just not quite there. Now, this is also a reason why prosecutors try to avoid lawyers as jurors. You know, we've discussed what is reasonable doubt, what is beyond a reasonable doubt. And I think for most people, the bar is here. I don't know where the base is, but the bar is here. For lawyers, the bar might be here. Crossing that beyond reasonable doubt threshold for lawyers as jurors, I think, is a little more difficult. And that is a good point. The 74% pedal could do it. That, you know, they're way back weeks ago, I mentioned testimony about the backup alerts, the auto stop is kind of what I was wanting to hear for murder too. Because if we believe in order to have struck John, she had to affirmatively turn off the safety systems, but that there is that lingering doubt. Well, was the storm messing with the safety systems? Was the storm interfering with the backup camera? And so there's just that little bit of lingering doubt that I would have liked to have answered. I realize that might be an unreasonably high bar, but I still think they could have had someone come in and testify about it. Especially if they had someone talking about the safety brake at under 5 miles an hour when she backed into John's car? Did she have to affirmatively disable it to set up an alibi? Did she have to set up an alibi, do it to set up an alibi? Now, we know she was drunk. That much is clear. To me, the evidence, even if we don't know exactly where along the street she hit him or exactly how she hit him, the evidence to me, the credible evidence, I should say, only points to she hit him. The fragments in his clothing, she hit him. The injuries, like I said, to me, the arm right at the correct height for the taillight, most of the energy goes to scraping, tearing, it is under pressure. So most of it goes into the side swipe energy, but enough to send him flying a little bit or stumbling back or something. Like, to me, this is the only possibility that makes any sense. He never went in the house. The cell phone data shows us the clear cell phone data, the one from the actual experts. Remember, Green poo-poos the idea of certifications because things move too fast that by the time you get a certification, things have moved on. But the things move too fast because of people like Ian Whiffen developing new tools to use. Ian Whiffen, using the tool he developed, Ian Whiffen showed that the Google searches were misinterpreted by the defense. The Trooper Guarino, taking all of the cell phone data into account, not just individual programs one at a time, but all of them, and overlaying them and saying, yeah, so they were half a mile away when the alleged 3 flights of stairs occurred. And it just, to me, you put all the evidence together, and to me, they proved the case beyond a reasonable doubt. Remember, it's not beyond all doubt. It's beyond a reasonable doubt. And as Mr. Lawley said, the jury can apply their life experience. They can make reasonable inferences. And it's not beyond all doubt. It's not, well, aliens could have backed their UFO into him. It's beyond reasonable doubt. And to me, it adds up to beyond reasonable doubt, DUI manslaughter, and probably murder too, but I'm just not quite there. And yes, DUI manslaughter is the charge, murder too, and then the third charge is like leaving the scene of a DUI accident or something like that. And as I've said, I'm not positive whether the legal concept of merger applies, where I don't know if in Massachusetts DUI manslaughter is a lesser included of murder too, meaning they would merge if she's convicted of both, or if it's not a lesser included and she can be sentenced to both. And basically, that, to me, that like, just, I understand my bias. I said from the beginning, I dislike Karen Reed because she has happily utilized Turtle Boy as her mouthpiece to ruin people's lives. And to me, that makes her a scumbag. But even ignoring that, looking at the evidence as unbiased as I can as a juror, looking only at the evidence presented in court. And remember, we don't have all of the evidence because the exhibits that were entered as exhibits but not published in court, the jury has those, we don't. So I can only look at what was presented in court. We don't have the niece and nephew's testimony. But, and the thing is, to play devil's advocate, she's drunk. Maybe she meant to peel out going forward and didn't realize she'd put it in reverse. Just playing devil's advocate. That would still be DUI manslaughter. I just, like I said, I'm so close to murder too. And as I've said, lawyers make bad jurors for this reason. And of course, defense attorneys don't put lawyers on the stand because even if the bar is higher, we know the rules of evidence, we know the rules of procedure, they can't pull the wool over our eyes either. So, and yeah, I hope they don't have to wait too long. As I've said, my gut is Friday. I could be wrong. I expect that they take at least a full day of deliberations. So we might get it, like the earliest I'd expect it would be Thursday morning. But, and that would be, verdict reached tomorrow late in the day, and they don't call people into court until the morning. But I'm expecting Friday. As I mentioned, if it does come in tomorrow, chances are I don't stream it until tomorrow evening. Just other stuff will be in the way. So just a reminder. So, and Painted Bronco, that is a good point. That's why, as good jurors, we should have listened to the jury instructions. I just can't today. I just don't have it in me. Another hour of listening to court. Don't have it in me. But going over the elements and the questions the jurors have to ask is important. It's important. And there's a reason they give the jurors instructions. Often in the closing, the prosecutor will go over the elements and basically, they'll play connect the dots. This is why this element is met. This is why the next element is met. With an hour time limit, for an 8-week trial, I don't know that Lolly had time to do that, but often that's what prosecutors do in their closing. Sometimes they even have a chart of the elements in front of them in closing and kind of to follow along with. But it's fine, we're going to get it anyway. So, but that being said, there's my verdict. I could be right. I could be wrong. The jury might completely disagree with me. They might find her guilty. They might find her, they might agree with me, mixed verdict. They might all guilty, all not guilty, hung jury. It could be a mixed verdict in that, guilty on DUI manslaughter and the lesser charge, and a hung jury on murder too. That's a possibility as well. Frankly, I would be less surprised by a hung jury than I would be by a straight not guilty of all charges. But, I could be wrong. And I'll admit, I've been wrong before. It happens. But, I am giving my unbiased opinion. I'm giving my unbiased verdict. I haven't been tainted by the Free Karen Reed crowd into giving a specific verdict, giving a specific analysis, and yeah. You may not always agree with me, but you'll know I'm telling you what I think. I'm not a good enough liar to not give you my opinion, basically. So, all that being said, it's been a long ride. Oh, it's been a long ride. I'm very glad it's over, and I am hoping with the verdict, none of us ever have to think of this bitch again. And on that note, thanks for joining me. Do all the fun YouTube-y things. And I will see you for the verdict. So have a good night, everyone. Bye-bye.